Hello everyone, I'm James Van Ingen. The date today is May 24th. It is a Wednesday, 2023. If you were noticing the letter that I just showed at the beginning of this video, it is postmarked May 22nd, 2023. I received the letter yesterday on the 23rd. What I'm going to do for those of us who have been following along with my story is read the documents that I received to you in this letter. It's a letter I've received similarly in the past when I've attempted to apply for Social Security disability benefits. The letter is dated May 18th, 2023. And its introduction is this. Upon receipt of your request for reconsideration, we had your claim independently reviewed by a physician and disability examiner in the state agency, which works with us in making disability determinations. The evidence in your case has been thoroughly evaluated. This includes the medical evidence and the additional information received since the original decision. We find that the previous determination was proper under the law. Attached to this notice is an explanation of the decision we made in your claim and how we arrived at it. And then it goes on to further explain the decision. If you disagree, you have the right to request a hearing. A person who has not seen your case before will look at it. That person is an administrative law judge, ALJ. The ALJ will review the parts of the decision that you think are wrong and correct any mistakes. The ALJ may also review the parts of our decision that you think are right. We will make a decision that may or may not be in your favor. You have 60 days to ask for a hearing. The 60 days start the day you receive this letter. We assume you received this letter 5 days after the date on it, unless you show us that you did not receive it within the 5-day period. As I have just explained to you a little bit, the date of it is May 18th. I received it on the 23rd. That's 5 days. Now, I want us to make a note here in previous videos pertaining to this story of mine. I'm receiving these letters 1 to 2 weeks after they're mailed to me, except this one. This one's on time. The others took a long time, if you will. It took longer than the 5 days, and I'm constantly having to appeal in order to continue with my claim. You must have a good reason for waiting more than 60 days to ask for a hearing. You must ask for a hearing in writing. And then it goes on to explain how to request a hearing and how the process works. After we send your case for a hearing, an administrative law judge will mail you a letter at least 20 days before the hearing to tell you its date, time, and place. The letter will explain the law in your case and tell you what has to be decided. Since the ALJ will review all the facts in your case, it is important that you give us any new facts as soon as you can. The hearing is your chance to tell the ALJ why you disagree with the decisions in your case. You can give the ALJ new evidence and bring people to testify for you. The ALJ also can require people to bring important papers to your hearing and give facts about your case. You can question these people at your hearing. And then it goes on further to explain if you want help with your appeal, if you suspect Social Security fraud. Oh, how to submit a new application. And then as part of this explanation, it shows, and we're going to count these. how many times I submitted evidence to the Social Security Administration thus far. Okay? We use the following medical and non-medical reports to decide your claim in addition to those listed on your previous notice. And I count approximately 13 of them. So I submitted evidence in this application 13 times. Some of that evidence included witnesses such as my healthcare workers, doctors, therapists, etc. Also, family members, friends, people trust, for backing my credibility on my word. We received a response, and you said you were unable to work as of May 11th, 2017 because of moderate mobility impairment, chronic neuropathy, dysgraphia, nervous disorder, PTSD, depression, and hypermetabolism. Your condition results in some limitations in your ability to perform work-related activities. We have determined that your condition is not severe enough to keep you from working. We considered the medical and other information, your age, education, and work experience, in determining how your condition affects your ability to work. We do not have sufficient vocational information to determine whether you can perform any of your past relevant work. However, based on the evidence in file, we have determined that you can adjust to other work. If your condition gets worse and keeps you from working, please contact any Social Security office about filing another application. And then it goes on to describe more about the administrative law judge hearing and the steps of the appeal, that I may have a representative or request a hearing to the Appeals Council for review. You or your representative may request a hearing by an ALJ in the Office of Hearings Operations. This ALJ has not had any part in your case. If you think the ALJ's action is wrong, you may request that the Appeals Council, which is located within our Office of Analytics, Review, and Oversight, review the judge's action. Your request must be in writing. We can help you fill out the special form for either a hearing or an Appeals Council review at any Social Security office. And then it goes on to explain that process. It also goes on to suggest what to do before the hearing to be prepared, at the hearing, and after the hearing. And implies that it is important to be punctual to the hearing. They can also pay travel expenses. Travel expenses can be paid by the Social Security Administration, and how all of that works. And then it finishes by briefly explaining things such as federal court action, contacting Social Security, etc., etc. Okay? I've had one of these letters and applications in the past. Actually, more than one letter, one application. What I'm about to explain to some of you is what my subjective experience has been thus far in dealing with these kinds of things. Some of you might go through these kinds of experiences. Maybe you already have. Okay? Back around the turn of the new millennium, not long after the internet was invented, and approximately the time of September 11th, 2001 attacks on the World Trade Center, a law in the United States was passed. It seems to me a lot of people have forgot that this law has passed, except for maybe lawyers and attorneys. maybe some medical professionals. But most Americans probably don't know about the law I'm going to explain to you. Please excuse me. I do not recall the formal name of the law. I'm going to give it a loose name that I come up with on my own. I call it a medical records burn notice law. And it goes like this. To briefly explain, any medical records older than 10 years must be destroyed. It's the law. Not destroying the records, the medical records, older than 10 years are inadmissible in a court of law. So even if we keep them around, you can't use them in the courtroom. Okay? That's how it goes. Now, my experience since the implementation of this law has been an endless loop of problems, just constantly going over and over and over and over and over and over again. I've already explained in previous videos to this one that the Social Security Administration is essentially implying that every healthcare worker, all of them with unanimous agreement that I am not employable, that I'm not healthy enough to be employable and earn an income and such. All of them examine me and they agree. They're like, yes, Mr. Benningen, you shouldn't go to work. You're a risk. You're a safety risk. I have medical problems that if I run certain kinds of heavy machinery and operate motor vehicles, etc., I'm a risk to my own safety and the safety of others. The Social Security Administration disagrees. They think I'm perfectly fine. I've got a few limitations. You heard it yourselves. I've got a few limitations. Oh, I'm fine. Yeah. This kind of law, what happens is a person like myself who was diagnosed with certain disabilities and impairments early in life, because we detected them early. We did good action. We detected them early in my life. I was diagnosed, and we learned how to provide accommodations for the disabilities and impairments, etc., so that I can continue living and surviving like anyone else. Okay? There are no records of that anymore, and the witnesses are no longer credible because that was more than 20 years ago. Some diseases are progressive. A person can be diagnosed early in life, and it could take a few decades before the disease progresses enough that the person is no longer safely employable in the job market. But by the time that happens, because of this law, all those records are destroyed. They're no good. Now, I'm about to say something that's probably going to upset some of you, if you're not already upset learning these things. But oh well, it's what I think, how I feel, if I'm being honest with myself and all of you. Thank you, baby boomers. My generation didn't invent that law. My generation wasn't even old enough to pass it. That's what you think everyone should be living under, as far as laws and rules. Maybe morals, ethics, values, principles. That's what they think is good, not us. I'm the kind of person, I think regardless of age, whether you're old or young or middle-aged, disabilities and impairments are disabilities and impairments. This law is ageist and ableist, and it's installed right into the very system. We don't need that kind of bigotry. And What we can do to change that now is very time consuming and resource consuming on a planet that undeniably has had a lot of population growth in a very short period of time. We can petition to have it appealed, ratified, etc. It could take another 20 years to get such a petition to pass Congress and get rid of it so that this kind of bigotry doesn't affect future generations. That's what we can actually do that would be ethical. I mean, we could riot and all of that stuff. I don't recommend those options. Let's not do that. A little protesting, if done responsibly, might be acceptable as well. But the petition itself, that's how we do it. Otherwise, millions of Americans are going to be living like myself. We'll live 4 to 5 decades of our lives as homeless and unemployed rejects. It's got to stop. It doesn't have to be that way. That's all I'm going to say for now. I'd like to thank you all for taking the time in your lives to view this video, to give us something to reflect back on and prepare for the future. You know the usual social media rigmarole. React, comment, share, and all that stuff. All right. Bye.